We want him to move here.
He can move, he can stay.
Would you rather stay where you are? All right. Well, after what we've heard today, this may seem somewhat frivolous, but moving right along. Mr. Chair and members, I present to you today Senate Bill 142. This is a bill that would prohibit the use of unmanned aerial vehicles, also known as drones, in the airspace above your property without your permission. And I would like to start out by accepting the amendments suggested in the committee's analysis. Under Article 1, Section 1 of the California Constitution, we have a guarantee, among other rights, a right to privacy for all California residents. Existing law protects the privacy of our residents in our homes, both by prohibiting others from entering onto our land without our permission, and by prohibiting others from capturing images or recordings of personal or familial activities in situations where one would have a reasonable expectation of privacy, such as inside our homes or in a secluded part of our backyards. This bill brings these long-standing principles of trespass and privacy into the 21st century and clarifies how they would apply to unmanned aircraft. Drones, as we know, have many potentially very exciting and useful, innovative purposes. But invading our privacy and our property without permission should not be one of them. When we are in our backyards with our families, we have an expectation that we have that right of privacy, just as I can't walk into your backyard or jump over the fence without your permission. I shouldn't be able to intrude by flying my drone in your backyard while you're enjoying the outdoors with your family. Similarly, I shouldn't be able to fly my camera-equipped drone up to your living room window and record what's going on in your house and expect that I'm not, by doing so, invading your privacy. And this is not just an issue for homeowners. The proliferation of these unmanned aerial vehicles has raised a number of questions for the American Chemistry Council about potential security threats to critical infrastructure, such as chemical plants, refineries, and electricity generating facilities. It also has raised the question in a number of other airspace which this bill does not cover, but which I am sure other bills will, such as jails, flying drones over prison yards, jail space, our state parks, our Capitol lawn, the White House, a variety of different places where the use of drones is becoming somewhat commonplace, but not necessarily appropriate. This bill clarifies and reinforces California's existing law on trespass and physical invasion of privacy in two limited but important ways. First, it clarifies that trespassing includes entry onto someone else's land with an unmanned aerial vehicle or drone. Second, it clarifies that physical invasion of privacy, which is entering onto someone else's land to record their private activities, includes entry by drones used to record private behavior. With the committee's amendments, this bill essentially recognizes a zone up to 350 feet above the ground where you as a property owner have the right to exclude drones. The bill will not affect what people do on their own land and still allows room for innovation in commercial drone usage. For example, farmers would still be able to use drones to monitor crop conditions, something that has become a very, very useful tool, and one which will continue to be such as we become more sophisticated and things that can be measured and so forth. So the drones have a very productive and helpful use in that regard. And Amazon would still be able to deliver a package to your door, which is a technology that is being developed. I'm not sure I'm wildly in favor of that, but again, this bill only deals with coming onto your private property without your permission to record your behavior as you conduct your own personal affairs with that right of privacy, which in California is so fundamental that it is actually written right into our Constitution. As long as the property owner has given express permission to be on the property, the use of drones will be allowed. The bill doesn't restrict what people can do on public streets or in public parks. It only addresses flying drones onto someone else's land, into someone else's backyard without permission. Again, drone technology is very exciting and offers a variety of potential uses, but we need to make clear what the rules are, because a lot of people don't know that this kind of behavior is an intrusion and isn't reasonable or acceptable. We need to make sure that we avoid situations where people start crossing the lines into someone else's private space by making it clear that this behavior is not appropriate. I have Professor Gregory McNeil from Pepperdine Law School and Samantha Corbin from the Privacy Rights Clearinghouse here today to testify in support of the bill and help answer any technical questions that you might have. So again, we are extending long established principles of trespass and privacy to include 21st century technology, drone operations, and the purpose, again, of this bill is to bring these concepts into the 21st century.
Okay, witnesses in favor?
Senator Jackson, Ranking Member Vidak, members of the committee, thank you for the invitation to testify before the committee regarding SB 142. As a professor of law and public policy at Pepperdine, I've researched the law and policy matters related to drones for nearly the past 5 years. I'm an advisor to multiple drone startups. I've testified before Congress as a guest of both the minority and the majority, and I support this bill. Let me sort of step back for a second to give us a little snapshot of the future and where I think things are going. I've been involved in some of the comment process for the FAA regulations, advised the White House's Office of Management Budget on the FAA regulations, and have been sort of a careful observer of them. And I think that SB 142 is really innovative because it doesn't try to be the bill that solves every issue, because it's so hard to do that with so many different approaches and thoughts about the merits of privacy, property rights, and innovation. And so as we look to the future, some of the things that we want to think about are that law and policy in the future when it comes to drones will be very granular and local. It's already. So down in Southern California where I live, there's an ordinance from the 70s that the city of Santa Monica is using to enforce against drones. It's the model aircraft ordinance that says you can't fly model aircraft on the beach. In the city of San Mateo, they have a similar ordinance about parks. And so what we're going to find is that there'll be these granular determinations about public land that'll be made by local officials through their zoning boards. With regard to private land, though, what we have is an issue that really is one that's traditionally governed by the state, where the federal government doesn't really have a role to play, and where the state can say landowners own a certain amount of space above their land. And I think that's what the innovative sort of hook that we have here with the bill. A lot of this a lot of the land use issues that we're talking about are going to be challenging ones because of the history of the case law that we've dealt with. Laws that were made for manned aviation at the turn of the century have sort of laid dormant for the last 100 years because really manned aircraft are not flying from ground level up to 500 feet, whereas that's the place where drones are actually the most useful. So that's why this is becoming an emergent policy issue for us. And what's exciting to me, which is sort of the geek law professor, is that California is in the lead on trying to craft a sensible piece of legislation that balances innovation, property rights, and privacy. I think SB 142 also helpfully clarifies what to date has been ambiguities in California law, not because of any neglect on our part, but just because of the advances in technology. There are a few things that I want to highlight in California law that I think are important here. First, I think the committee is already familiar with the Cosby line of cases, beginning with Cosby, subsequent interpretations that have said that landowners own the airspace above their property, but then the court stops and leaves it undefined as to how high above the landowner's property the landowner actually owns. SB 142 wonderfully takes away that ambiguity. And I think that one of the questions that naturally arises is, why would we do this? Why would we create a line? And the bill creates a line at 350 feet. And so the immediate reaction is like, well, why not 300? Why not 400? Why not 500? And it sounds arbitrary. And you know what? It is, because that's what we do as lawyers and you do as lawmakers. Why is it 25 miles an hour on a residential street as opposed to 27 or 30? Because we make a judgment call that we need clarity for enforcement purposes, and we think that 25 miles an hour is about right. And here, this is similar what we're doing. We're trying to balance room for innovation from about 350 feet up to 500 feet to allow transit zones for drones, to put them kind of on par with publicly operated manned aircraft. But then below 350 feet, we're saying, well, maybe we're going down a little bit too low, and when you get too low, the bill will lose some of its effectiveness. For me personally, understanding the technology and the law, I think an appropriate line to draw could be anywhere from 200 feet to 350 feet. I think we can argue about the merits of one versus the other. I'll tell you that the trend is that the FAA is looking more and more towards ceding 200 feet and below to local authorities. And the reason for that is that 200 feet is the line at which physical structures have to start being lighted and put on charts as obstructions. And the airspace below that is the airspace which the FAA does not pay much attention to except for the takeoff and landing of aircraft. And so while we might choose the line at 350, which I think is pretty protective of privacy, we'll start to see the possibility that nationally the line might drop lower to about 200 feet, in which case we might make a judgment call to calibrate. But my sense is that this is a really good and appropriate balance of privacy and innovation. In the Q&A, we can go into some of because I realize I'm going over time, we can go over some of the specific statutes that in California that I think to speak to this and the impact that the bill might have on trespass. But I think it overwhelmingly does a good job of balancing privacy rights, property rights, and innovation. Thank you.
Next witness.
Madam Chairman, members, Samantha Corbin on behalf of the Privacy Rights Clearinghouse, a nonprofit consumer education and advocacy organization in support of this bill. As the chair mentioned, the emergence of drone technology has created new opportunities to invade the privacy of Californians, yet little legislation or regulation exists currently to address the vast implications on individual privacy that widespread drone use can pose. We're really appreciative of both this bill, which is a very clear targeted effort, as my colleague next to me mentioned, to address part of this problem, as well as the hearing that you previously held and your other work on this issue. Previously, as the chairs mentioned, trespassing really was a ground level activity. Now, minimally regulated drones have the potential to be used as peeping flying toms. There really are potentially flying cameras everywhere by way of these drones, and use is only expected to increase. I've definitely heard folks say that we're already in a surveillance society, that in many cities there are cameras everywhere, that anything you do or have that's electronic, such as your phone, is really already a surveillance tool, one that can capture, store, and transmit audio, visual, and digital data about your whereabouts, activities, and private lives. In some ways, the erosion of individual privacy has been allowed to persist as commonplace and necessary. And again, appreciate the chair's effort here to address just one important piece in a very tangible way that is a privacy challenge associated with this new technology, and urge your aye vote on the bill.
Mr. Chair, members of the committee, Randy Pollack on behalf of the American Chemistry Council. As Senator Jackson indicated, we are strong supporters of the intent of the bill. Proliferation of drones, we have a lot of concern with that due to their surveillance potentially over chemical facilities. We have seen other states in the country, Louisiana and Arkansas, pass laws to prohibit the use of drones for surveillance over critical infrastructures. And we look forward to working with the senator to make sure that there are adequate protections to ensure the security of not just chemical plants, but other infrastructures in our state. Thank you.
Any witnesses in opposition? Questions?
No. I think there's some opposition. I'll wait till after the opposition. Is this opposition?
I'm not in opposition. Because I represent the Silicon Valley Association of Unmanned Vehicles. And while not in opposition, I just wanted to express our concerns with the bill to make certain that we don't create anything that would impede the growth of our industry. I don't think that the bill does that, but nonetheless, I wanted to express our concerns with regard to that because it's a rapidly growing industry and one which will have import and consequences that none of us sitting here at this point really can understand or even predict. So I just want to express that concern that we not do anything that impedes that growth. And thank you very much for your time.
Hi, my name is Greg Kretzinger. I'm an ecology professor, actually, and do a lot of field work as an ecologist. I'm based out of Berkeley right now. I'm part of the Beatty Biodiversity Research Center. My concern with the bill as a field biologist is that we use drones all the time to count seabirds. We use drones to survey forests, to map endangered species, to track invasive species. Not all of this occurs directly on research property or in nature reserves or in public space. It occurs a lot on private land. And so if I'm flying and surveying a stream, for example, with a thermal camera, or mapping agricultural areas, which are often private land adjacent to other private land, sometimes not continuous, my concern is that there's no exceptions really onto, I'm not here to advocate for paparazzi. I'm here to advocate for scientists not being charged for trespassing. If we're surveying a stream and happen to be, that survey might involve on private property, the edge of a private property or whatnot, that we're not charged with trespassing if we're trying to monitor take ecological data for climate change, for example, or tracking wildlife, et cetera. So it seems like there's a bit of ambiguity there for scientists, and that's all.
Thank you very much. Senator Hertford.
Are you on the Pepperdine Public Policy School or the law school?
I'm a professor at the law school, tenured there, and by courtesy at the School of Public Policy
I'm on
Center.
the board of that school. I don't think there's any conflict. I don't get any money for it. It's public service, but want to disclose that.
We thank you for that,
There's a couple of questions. Number one is, isn't this really, when you talk about this, what you're really doing is giving up jurisdiction on this issue to the federal government? Because 350, I think you told us, or maybe you told me in a private conversation, Chairman, Madam Chair, but is the federal jurisdiction. And it refers to the federal law here, Title 49 U.S. Code. Anything below that is undefined, depending upon the Cosby case. We don't know what that looks like. You have an opinion of 200 to 350 feet. The question is, maybe it's the intended consequences, I don't know, but what we're really doing is saying that anybody who wants to fly a drone has to get permission from the federal government, and we've taken the state out of the responsibility to be involved in that. I'm just asking that question because that's what it looks like to me.
You have to get, if you're going to fly, first of all, the FAA, as I understand it, the federal government claims control over all airspace over 400 feet.
Is it 400 or 350?
Senator, the 350-foot line, let me start with what the FAA claims. The FAA claims that publicly navigable airspace, when it comes to drones, is anywhere that a drone can operate.
Anyway, the question is this. Let's be specific on the bill. The bill says unmanned aerial vehicle below the navigable airspace as defined. So who cares what that is? It's defined by the federal government. So if there's a line, anything below that, you can't fly it. Anything above that has jurisdiction by the feds. It's navigable airspace. Is that fair? Am I reading that wrong?
I understand what you're saying, Senator. So with regard to the provision that you're citing, the bill says below the navigable airspace, but the FAA says navigable airspace is anywhere a drone can operate. And so by virtue of that, paragraph 1 means that the drone will never be operating below navigable airspace, which is why the amendment surfaced since the bill's introduction to now to actually clarify
350 feet.
the 350-foot line. Because right now, the federal government claims that drones can fly anywhere. So let me put it in practical terms. If I get a drone today, I can fly that drone at 15 feet. I can fly it over the public sidewalk at 15 feet and right into your backyard at 15 feet. And there are presently no regulations at the state or federal level that would prevent that.
No, the purpose of this is great. I'm just trying to understand in a broader context whether there's unintended consequences here, because if we are giving that jurisdiction, and if in fact, look, what do we care about a drone flying at 330 feet for as long as it doesn't have a camera? If it's a commercial drone trying to deliver something, and I'm a little wheezy on that too, but try to fly something to your neighborhood because you bought a new book and they want to deliver it the same day, and it drops it in your yard, and they have permission because it dropped in your yard, but flies 330 feet. It's not really causing harm to anybody just as a camera, right? Aren't we really worried about the paparazzi people who are looking into your world? Is that really what we're looking at?
We're also looking at the fact that drones can be difficult to fly, and they do crash. And they are mean machines when they crash because they have the rotator, which could decapitate you. I mean, they are dangerous. They can be dangerous. So we don't want them flying. I don't think you want them flying in your backyard if your grandkids are there playing on a swing set that you have. I mean, is there a point at which there's some place in your life that you have control over? How about your backyard? And the other point is that there's a dispute as to whether or not the FAA really does have complete control over airspace that's below what we are defining as 350 or 400 feet. The state has, we believe, the ability to assert control over that, irrespective of what the federal government has decided. So we are in dispute over that, and what we're trying to do is take charge and control over the airspace that we believe the state should have jurisdiction over, which is arguably up to 400 feet. We say 350 as a way to sort of split the difference. But we want to take control of that airspace. I don't want the FAA saying a drone can fly anywhere, because the right of privacy isn't written into the federal Constitution. But it's a fundamental right for those of us here in California, and we want to make sure we protect that right.
Yeah, but the question is what the privacy level is. I mean, for example, the commercial issue, I'm just looking for the unintended consequences of the commercial space. We have an airplane that flies over, can land in your yard. We have satellite spies that can read your license plate off your car, okay? I mean, we have those capabilities now, which
That's
is
the
pretty
next
meaningful.
bill. That's the next bill.
So,
This is
but
this
the
one.
question
We look
is-
forward to
But the
that one.
question is, in terms of that issue of, are we, in your judgment, as an expert on this, are we, given the language of this, giving up the right to control, as long as this controls, are we giving up the right to control the Amazon types of the world to engage in commercial activity? Because that's how I read it.
Not at all, Senator. So it's actually the opposite. As Senator Jackson stated, what this is this is the state of California asserting control over low-altitude airspace, which is presently not defined.
You're giving a
in FAA.
private right of action to a litigant who then can sue you and get damages, and you got a new lawsuit. It's not the state of California. It's the state of California declaring this to be a civil tort. It's a different thing, counsel. It's a different thing. And now all of a sudden you've created that, and I'm just trying to understand the unintended consequences. What about, how do we define the term of land? FAR. You go out and you build a building. Your FAR, 350 feet is only 35 stories. What does that look like? At what point does it? I'm just trying to get more definition. I'm not, look, I like the policy. I'm with you on it. All I'm trying to do is to try to give it a little bit of a more precision so we don't run into unintended consequences. That's all.
Senator, let me give you some precise answers, and
Yes.
let's talk like lawyers. So the bill will, by amending 1708.8, it basically creates for the privacy tort that we're first concerned about. We won't have a problem with sort of an Amazon drone running afoul of that, because to prove the privacy violation through the amendment to 1708.8,
A knowing standard.
it's without permission to capture any type of visual image, sound recording, or other physical impression of the plaintiff, engaging in a private, personal, or familial activity, and the evasion occurs in a manner that's offensive to a reasonable person. So to reach that standard, we're more in peeping Tom and paparazzi territory
that.
than in inadvertent observations. There's a small risk here that because trespass is largely common law in California, that we will read in from this 350-foot line some possibilities of trespass litigation. But Silicon, I advise not for money, a company that has decided to start allowing people to register their property as no-fly zones. It's called noflyzone.org, and they're going to make that geolocation data available to commercial manufacturers of drones and people like Amazon. So Amazon will know which places they can fly over and which ones they cannot, and obviously, but California would cap that property right limit at 350 feet. So the Amazon drone could traverse my property, because I don't mind, at 351 feet, and perhaps someone else's property at a lower altitude. And so we're empowering Silicon Valley to create solutions based on how people want to manage the permissions with regard to their property.
I apologize, can't follow the amendments. I was reading the bill, I'm trying to find the amendments in the analysis.
And if you're concerned
Yeah.
about litigation, let me tell you a true story that happened not that long ago in the great state of New Jersey. Somebody flew a private drone into a fella's backyard. He wasn't particularly pleased about it, so he got out his shotgun and he shot it down in a neighborhood. So he's shooting off a firearm in a neighborhood. He destroys the drone. The fellow who owns the drone sues him for conversion and wins. So that the guy's now got to pay the drone owner for a new drone.
Can't follow this.
That's a lawsuit. And that's when we want to prevent that lawsuit. We want to prevent the flying of that drone in a neighborhood. And so when it comes to the litigation aspect, what we're really trying to do is define where an individual can and cannot fly a drone. The same way we've told that individual, you cannot jump your neighbor's fence and peep in his backyard. What we're doing is we're aligning the same activity with a drone as the very activity of a peeping Tom or someone who is trespassing on your property, coming on your property without your permission. And in this case, with drones, usually they're recording something as they kind of look you in the eye and record that and take it back to the neighbor. That should be an invasion of your privacy, especially under California
I
law.
apologize, one more follow-up question. I'm sorry, just it's important issues, and we end up not doing the homework. This is the policy committee, and I want to ask it, it sounds like a dumb question, but it's an important question. What's the definition of land in this bill?
So the definition of land is not contained in the bill, Senator, but we have a definition of land in California Civil Code, Section 659, which defines land and basically in a way that states subject to limitations upon the use of airspace imposed and the rights in the use of airspace granted by law. So we actually have a few other provisions that speak to airspace, and throughout the California Code, we have provisions that basically state landowners own certain rights as defined by the California legislature in their land, and also certain rights in airspace. So there's actually a separate set of provisions in the Public Utility Code that command the state not to create laws or not to create regulations that burden the use of airspace. And this is why we've had this complex sort of balancing act, I think, in the drafting process, that to get to the point now where we've drawn this line between the private property rights below and the navigable airspace above. And I can provide the committee with the references to some of those statutes, Senator.
Essentially, what we are saying is if you own the land below, that area going up to 350 feet is land that you are entitled to be protected from the flying of a drone that is now on your private property, going up from the ground up 350 feet within the parameters of your property.
What if you got a 35-story building?
That's another issue. Again, and there's another example not long ago where a woman living on the 15th floor of a building, an apartment building, woke up one morning to find a drone peering into her bedroom.
That's what we get to.
And at some point, right now, again, I'm trying to set a baseline here. There's no law whatsoever in this subject. We're starting, this is a first step to define what is private land, which is to be protected under trespass law from drones, 21st century technology, which we never really had to deal with before, unless arguably model airplanes. And if we pursued this as we've done model airplanes, it would be even more stringent, because model airplanes are limited to, they can only fly in designated places. What we're trying to do is balance some of the commercial uses of drones and the concerns that people have about the potential benefits of the technology versus the right of privacy that we all have within our own home. That's what this bill tries to do.
Thank you, Mr. Chair. Thank you for bringing this forward. I'm supportive of the objectives. I would like a little more articulation of the question asked by the gentleman from UC Berkeley, the potential beneficial use of drones in mapping, survey operations, agriculture, where in the operation of the drone, you may have to go across private property, but without the intention of doing surveillance, are you exempted then? Can you fly across private property for the purpose of survey or ag, or do you have to get the permission of the property owner whose airspace you would transit?
At this point in time, that hasn't been specifically clarified. Ideally, if you're flying a drone over private property, the same way if you were going to drive over private property, you would either have to get permission, or I guess you would technically have to get permission to do that, or else you're trespassing. But again, the consequences are that if it's an inadvertent trespass, I don't think there's any kind of civil recourse that one gets for it. It's just setting parameters for what is the behavior.
One thing that might be helpful as this moves forward, as you both articulated it, the objective is to prevent surveillance, snooping, an intentional invasion of a property owner's privacy. And if that's the stated objective, then it seems that there could be an exemption or description that if it's incidental to, if a technical trespass is incidental to another permissible use, that it doesn't constitute trespass. But again, it opens, somebody still may not want that drone going across their backyard, even if that drone isn't looking in their window or the intent of the operator isn't that homeowner's property. It's the neighbors for whom they have permission to do a survey of the neighbor's back lot, for example. So I just fear that we're going to create potential problems for important uses that we wouldn't oppose because their goal isn't to invade anybody's privacy, but in so doing, they may technically be violating.
There's another example. We got a call after the bill was introduced requesting that we also exclude the drones from being on state parks because they interfere with wildlife. They are a cause of concern. They are a danger to, and certainly if someone is taken a 5-mile hike up a trail and wants a little peace and quiet and suddenly they're confronted with a drone, that can be unsettling. That's not what we're trying to do. We're really, this is a very minor step, and I certainly will take into consideration as if we can move the bill forward, some of those, if you will, unintended consequences. Are we going to define incidental? The goal here is not to create new litigation. It's just to give people an expectation of what is appropriate and acceptable usages of drones for recreational, and these are primarily recreational. We're not talking about commercial. We're talking about recreational use of drones. Right now, it's the Wild West. There are no rules. This takes the right of privacy and says, look, drone in a person's backyard, unless you have a permission, that is a trespass. That's a flying peeping Tom, I guess is the best way to put it. That's what we're trying to do. I'm certainly happy to continue the discussion and, because this is a whole new area.